Welcome, ladies and gentlemen, to the Wasanii Tunajisort webinar. And let me also again welcome you all on behalf of the partners, that is UNESCO, the Creative Economy Working Group, Alliance Francaise, UNESCO, the Go Down Arts Center, and Toeza Communications. My name is Kimani Njogu. The idea of the Wasanii Tunajisort webinar is really a consequence of conversations that we have had under Wasanii Arts Kenya. And those conversations were held on May 21st, June 25th, and July 30th. There were also additional conversations that were internal, organized by the Creative Economy Working Group, that really indicated there is a need for continued development of the sector, of the creative sector, not just in Kenya, but across Africa. As a result of the Wasanii Arts convenings, a number of recommendations came out, and I'd just like to highlight a few of those recommendations before we begin the development. The first recommendation that was came out of the conversations was the need to continue reviewing the Sports Act and Social Development Act and its regulations and guidelines, because currently those guidelines are skewed too heavily towards sports, and the creative sector feels that they are not catered for by the fund. And therefore, in meetings that we have had with the fund, again, as partners, we have articulated the need for that revision. And I think that in the case of Kenya, there is need to really follow up with the leadership of the fund to make sure that the Sports Acts, Social Development Fund regulations and guidelines are revised to support the sector even more pointedly. The other recommendation, which was again emphasized through the Wasanii Arts Kenya meetings, was the need to really prioritize the policy frameworks to support the creative sector in terms of the culture and arts policy, the music policy, all those other critical documents that are supposed to support the environment in which the creative sector works. With regard to the digital platforms, a very strong recommendation came out, and that is that there is need to consider these platforms as public good, and really to open them up completely so that they are used by creators to distribute their products without feeling that they are under too much censorship and constraints, and that they are also accessible and affordable. And that means that the various technology companies need to step in and support the creative sector through affordability and accessibility mechanisms. An issue of data and statistics was again underlined during the Wasanii Arts Kenya meetings, because again, without data and without the research, it's very difficult for us to plan and budget and really nurture the growth of the sector. And therefore, the Kenya National Bureau of Statistics and the various partners were asked to support the collection of data and statistics from the sector. And the sector is ready to provide support so that this data is available. Another issue that again was emphasized and recommended was really to build mechanisms for the payment of royalties for creators, because in any case, creators receive only a percentage from their creativity, and yet even that getting that percentage it is very slow, sometimes very unpredictable, and those that are supposed to pay do not do so in good time. And therefore, there is need to continue strengthening those mechanisms for the payment of royalties and all the dues that the creative sector is entitled to. So those are some of the recommendations that came out of the Resili Arts Kenya. To start implementing some of those recommendations, the partners came up with the Wasanii Tunajisort series. And we will be doing this series throughout the remainder of this year. And the first conversation is on copyright, and I'd like now to hand you over to our colleague, Kathy Mujomba, who will moderate this meeting and really invite her and Liz Lenjo to run us through the remainder of this webinar. Kathy, welcome. And I think you're on mute.
All right, thank you, Professor Asante Sana. I think it was a very comprehensive summary on the recommendations, so that at least as artists, we're also very comfortable knowing that things are moving ahead. Sometimes as artists, we're asked, is anything being done? And we're very quick to say no, but thank you for that, Professor. And I would like to now introduce Liz to say something. Now, Liz is an advocate in IP, and she's a fellow teacher in a course that we are running. And she's an artist as well, which I think not many people know. So, karibu sana, Liz.
Thank you, Kathy. Thank you, everyone. It's a pleasure to be here. As Kathy said, I'm an advocate of the High Court of Kenya. I practice under the style of my IP legal studio. So my firm is, we specialize basically in intellectual property, entertainment, media, and fashion law. So we are lawyers of the creative economy, and we really believe in the potential we have. We've been privileged to negotiate some interesting commercial ventures for artists. So with that kind of background, we'll be able to shape some of the emerging conversations around copyright in Kenya.
Thank you. So now, you know that as artists, sometimes we get very frustrated when we discover that our creative work has either been stolen or copied or misused, vandalized. You know, we are very unhappy about the way our artwork has been handled. And sometimes we feel very disadvantaged about that. And I think that's why the importance of copyright is there, because it is the one that creates a certain environment for us to thrive. So today we will be discussing copyright from a case study perspective. So I want to thank the professor for taking us through the policies and the groundwork, the recommendations for the policies, but today is only about case studies. What are we as artists on the ground feeling? What are we as artists on the ground saying, experiencing? And then Liz, who will be our expert for the day, will try and guide us through so that copyright is no longer this thing out there which we don't quite understand. So karibuni sana. So I go straight into it, and I'd like to introduce the first case study. We hope that the recommendations that we have here today will help. It's from one person, but different people will be able to benefit from that. And so Joanne, thank you very much, Joanne, for writing in. And her question is, which digital techniques can you employ to protect your content within the digital space against online piracy or copy? Are there codes or something that you can embed into your content that alert you whenever your content is stolen, or sites that can help you get this information? Liz, what do you think?
So this is one of those areas in copyright we're really struggling with, not only nationally, but internationally.
Right.
And because, again, the innovations around the internet space are very robust. They're always changing with time.
Correct.
So when we just think we found a solution, then we realize, oh my gosh, we figured out how to PDF or sort of package a document and it can't be interfered with, and then some genius software developer comes through and has created something. So we find we're always grappling with that. So that has been the greatest challenge. But yes, you keep trying to do that. put your watermarks in your images, because again, under the Copyright Act, if someone interferes with that kind of information, it constitutes a crime under the Copyright Act or something illegal. It means tampering with digital rights management information, the words and our Copyright Act. So, you would find someone guilty for copyright infringement as well as tampering. So those are two offenses under the Act. So, such small things assist. If you can figure out also how to ensure you always have your metadata around your creativity online, it also helps, because with the metadata, you find that anyone who's infringing, they never stop to think about the metadata. So when you're trying to figure it out or getting your team to look at your work online, just by that small tag, you'll be able to see who else has reproduced your work, and then you can be able to trace them. But in the meantime, we're still trying to see, even at an international level, what else can be done. But it will be something that we'll continue to struggle with because of that dynamism around the internet.
Right. And then when I do find somebody has done something, has infringed, because infringing is actually taking and using my work without my permission, or what can I do?
So that is immediately, you first look for a lawyer. We have had this thing where we feel like the social media is a court of justice. So then what we end up doing as we put our issues online, destroying the kind of strategy that your lawyer would have, because now you start putting all your cards on the table, even some of the things the lawyer thought, oh, I have a gold card, and then boom, you're putting it everywhere, you're on Twitter, you're on Facebook. So don't do that. The minute you do that, you even destroy the goodwill, because in law we have something called goodwill that will also bring the other party to the negotiating table, and they will be able to say, okay, you know what, we did a mistake, we are slapping ourselves in the wrist, what do you want, how do we negotiate? The minute you put it on social media, the goodwill also goes, so the other party will now even use it against you. In some instances now it will resolve it to another area of law. It might be an issue of defamation, so even maybe it might be true, but then you go ahead and use unkind words or derogatory terms and things like that, then it just swells into something else, right? Okay. So it's always important to look for a lawyer.
Yes.
And then now your lawyer, start even with a local lawyer, because like what we would do is we'll go online and investigate the content, we see if we can find this person, so we'll do all the due diligence on your behalf. If they're in a foreign country, we'll be able to talk to our partners, our of counsel as well, and say, oh, this happened in America, in which state, in Atlanta, or in Atlanta, Georgia. So we find counsel there and say, okay, we have a problem here. How can we work together, negotiate something on your behalf, and then they're able to pursue that on our behalf in that other country.
You've brought up something very interesting, because now we are talking about cross-border.
Yes.
Meaning that I'm in Kenya, my work was brought down or was copied, infringed upon in another country, and then now explain that process again a bit more clearly for us. What exactly is happening?
Okay, so my work, let's say it's your work.
Yes, my work.
Your work was online. You had put it maybe on your website.
Yes.
Then Liz, who is based in Canada or whatever, decides to take it and duplicate on another platform, right? Then you get to discover that, and you go to the content, you find it's actually your content. So I'm excited when some of them don't even remove your name. It's there, but it's been reproduced. Under the Copyright Act, you have the exclusive right to reproduce as the author. Yes. This person, by them putting it on another website, they have reproduced. So it is copyright infringement.
Yes.
So in that respect, then don't go online and start yelling about it. Look for a lawyer, call so and so and say, hi, I heard you're a copyright lawyer. This is my problem. Here is the link. How can we work together? And they say, okay, we're investigating. So immediately now we go online. We look through and see, or we say, oh yeah, by the way, it's true, it's copyright infringement. On my end as a lawyer, I will be able to even just go and compare our Copyright Act to the Canadian Copyright Act and figure out are we on the same page, and I say, yeah, I think you have a case in Canada. Yes. Let me start looking at a Canadian lawyer we can work together with and see how we can help. So you just take your back seat. As the lawyer, I am initiating the process. I'm negotiating for you. We're also having that interaction. I'm trying to figure out what kind of amount we would be negotiating for you, because remember, again, cross-border, there's the Kenyan rate, there's the Canadian rate, so it's all about also negotiating. Remember that with the creative space as well, we don't tend to do well with fights, with even litigation and all that stuff. It interferes with your creative process. Half the time now, Kathy will be sulking, she's just fighting, and she's not creating, so she's not making any more money. You're stuck in this place.
Right.
So the lawyer will be able to do that for you, and we negotiate. you get a settlement agreement is signed. You find some of these settlement agreements as well will have confidentiality clauses.
Okay.
So we've had quite a number of cases that have been settled, but they will always be bound by confidentiality. So you will never hear the artist who had a breakthrough yelling about it because they signed an agreement.
Right.
Yeah.
Right. There's something that we talk about, take down notice. So somebody has infringed on my work, I write to the platform concerned and I give them a take down notice. What is that?
So basically, especially with the social media platforms, Facebook, Twitter, Instagram, I'm not sure about TikTok because I don't use TikTok, but at least these main platforms,
Yes.
at the terms and conditions, they provide for takedown notices, which is a copyright mechanism that allows an author or an owner of a work to basically report a copyright infringer to the said platform and send a message and say, hey, I've seen this page infringing on my copyright, take it down. Right, so you will find that some of them will have direct copyright takedowns, or some will have a warning mechanism. So this infringed the first time, they will poke me, they will send me a message and say, the content you have used is infringing on someone else's copyright, take it down. Strike 1.
Yes.
Strike 2. Strike 3, I do it again, I'm out. They even remove my Facebook page or my YouTube page, and I'm out. Yeah, so some of them will have like a strike. Others might just be outright. They will decide to remove everything. And then maybe now you can plead your case through the community guidelines and mechanisms and say, you know what, it was only one picture, reinstate my page or whatever it is. But that's what takedown notices do for an author.
Thank you. Now, I know we started a bit backwards, but it's just so that we can understand what the program will actually be doing for us. But maybe you could tell us, Liz, what is copyright? Then I'm an artist. Which pieces of mine are copyrightable? Because the way we're assuming that everybody knows what can gain copyright, what cannot, and then also what does it take? How do I get copyright? Yes.
So first of all, what is copyright? So copyright falls under the bigger umbrella of intellectual property law. And we'll start with the common phrase we like to hear. I want to patent an idea. Hey, my problem. We don't patent ideas. IP law helps you to protect the idea the expression, let's say the expression of the idea loosely. Yes, so it's you coming to a lawyer and say, oh, I have an invention that does this, maybe if it has mechanical elements and whatnot, then in that regard, if it's mechanical, it's a scientific, we're talking about a patent. And again, with a patent, we now interrogate.
Exactly.
Is it novel and new? If not,
exactly what are we doing?
It's a new improvement. We also have what we call a petty patent or a utility model. So we don't patent ideas. Yes. And patenting is the highest form of protection. So that means you have to be the only one in the whole world to have come up with it. So as an artist, you did not come up with the idea of painting a brush, writing a script, all that, you didn't come up with that. So that becomes very difficult to talk about patenting. So, and that's how you also tell when someone is misleading you, when they tell you you're patenting an idea, you're not. So copyright for us in the artistic space is what we get to use predominantly for protection, because now copyright protects the expression of ideas, so not the idea itself. So remember, in copyright, we're talking about artistic works, literary works, and software as well, which I'll expound shortly. So, but when you look at artistic works, literary works, they are very related to each other, even in the subset. So if it's artistic work, it's a painting, a sculpture. So I could do a painting of a giraffe, and then you do a sculpture of a giraffe. You have your copyright, I have my copyright. It's about how I did it, how I expressed it.
We can also both do paintings of giraffes.
Exactly.
In totally different
ways. And even if you just sat down and observed a giraffe right now, and we both painted it to a T, you have copyright to yours, I have copyright to mine, right? So that's what we always need to understand regarding copyright, it's the expression. So when we're talking about literary works, we're talking about novels, we're talking about stories, we're talking about poetry, we're talking about the plays, the scripts of all these plays, textbooks are also included, speeches are also included, letters can also be protected under copyright. So anything literature-wise is under copyright.
Anything that I'm writing.
Yeah, anything that you're writing. Yeah, so and what you're protecting is the expression. not the concept, because that's the other thing people imagine, that I have come up with a concept, I am protecting a concept. No, we're not protecting concepts. It needs to come very clear. Because, we hear, like one time there was a case where someone came up with this idea of, I think, chamas having a show, and they would have, I think, like some sort of competition and whatnot. So it was just a concept, right? It wasn't an idea that is sufficiently developed, because that's also what copyright looks at. Have you sufficiently developed something such that if I was to borrow or copy it, at the end of the day, they would say, hey, this is Kathy's work. There would be somewhere they would go to and say, hey, by the way, paragraph 5, 6, 7, 8, and 32, and that is Kathy's work. So it has to be sufficiently developed to qualify for copyright, which is something that we really need to understand and process.
Okay, fantastic. So let us go now to the second question. I know we're being a bit, please do send in your questions, because we're still open. I can see there are some people who are giving us some good information. So thank you very much for that. Let me go to the second question. Now, there's someone, Lean, has written in and said, I have a book and shared my story and included my psychological experiences, so that the process of going through the book, one is able to process their grief. So I think she wrote a book, she shared some of her personal experiences in it, and of course it has, because she's a psychologist, I suppose, because it says it has some psychological expertise, so she's created this book. And she's asking, how and what can I copyright in the book? What is the process for copywriting the book?
Okay, so let's start with first the process of copywriting. So with copyright, it's inherent, it's automatic. The minute I write it down, I automatically have the copyright, or the minute I'm able to record it or put it into some sort of tangible format. Now, the challenge has been, because remember we're talking about expression of ideas. Me and you can express the same idea in an almost similar fashion, right? So because over the years we've been having those kind of challenges, there will be lack of access, but then you will come and say, oh, but at least you've infringed on my copyright. And I never knew your work existed, and there's some minor stuff, there's some stuff that qualify even for as concepts. So because of that kind of issue, people in the film industry were likely to do the same kind of work. Again, we're also exchanging ideas behind the scenes and things like that. So you would find people are always fighting each other. And then eventually, internationally, they had a conversation about registration of now copyright works to curb this challenge. So we then since moved towards the registration. Now in Kenya, it's not mandatory under our Copyright Act, but it's prudent, which means that at least once you've created it, it's great that you go and register.
So let me get this right. When I create my work, I don't have to register it to anybody. I automatically get that copyright. That's what we're saying.
Yes, that's what we're saying. Okay. But it's important now you register it because of any future engagements you're likely to have, either contractually or even just verbally, even with your friends. I could sit down and get excited. We're having drinks, and I say, Kathy, I have this amazing project. Go back Kathy there with her money. She's like, doesn't know anything. So, if you do that, I'm able to pick out my copyright certificate and say, hey, my friend, in 2012, I registered. Here is even a script, and maybe if I'm lucky, I even have that receipt where we were having drinks. And I tell you, remember, because it was on this day. So that is why that registration is important. Because again, it's like when you buy a shamba, you get a certificate or your title deed to say you're the owner. So it's the same thing with copyright. You want to do that, right? And you always read it when it's in its rawest form. Because artists sometimes you're like, oh, it's not perfect.
It's not ready.
It does, and you
have a few more tweaks.
You do it when it's even raw. You can do part 2, part 3, you still register, and it's an affordable process because now copyright is under Kenya Copyright Board, and they're online, copyright.go.ke, and you'll see a link to now their new portal. I think it's called nrr.copyright.something. So you go on just online and you create an account, and you're able to choose. I know I am an author, so I'll be literary works. I put all my scripts there. So even if tomorrow I change, I plan to just re-register, and then I'll get a subsequent certificate for now the new amendments and the new changes. So you can keep it current. So you do that first. Now in her instance, what can she copyright? the expression. So even the way she would express her expertise would be different from how another psychologist will express their expertise. It's very contextual to her book as well. So all her story itself, the way she's expressed it, and especially where there's very unique elements, it's how you
her personal story,
that's what
you know,
and
talked about,
and how she's talking about her personal story. She wants to make sure that it's very distinct, that, you know, if anyone else tried to share a similar experience, they would have to be very unique and different, so that then they can coexist, or she can prove some sort of copyright infringement by someone copying from her book.
Okay.
Yeah.
Okay.
So that registration is always important.
Now, when I go to Kikobo, because you said we go to Kikobo, we're going to register this. What am I doing? So I get there.
So you go online. Now it's an online process.
Online.
No longer,
online. So I'm not even going physically.
Physically.
And this online means that it doesn't matter where you are in Kenya, you can access it. So now registration
anywhere in Kenya,
open.
even if you're abroad, you have.
And you're a Kenyan.
Yeah, even foreigners.
Even foreigners are able to copyright their work, and because they're in Kenya or because they're abroad.
Yeah,
how does that work?
Yeah. So you remember, intellectual property generally, not just copyright itself, but patents, trademarks, they're all territorial, right? So you protect based on the countries of interest, commercial interest. So if I know, like, for example, I am a painter and I'm going to take some work, I don't know, to the US.
Right.
I want to protect it beforehand, right?
Yes.
I register the copyright through USPTO. I get my certificate.
USPTO,
the US Patents and Trademark Office, and I think it's a copyright office has a branch, I think, but they are basically a similar office there.
Right.
Then you register, because you want, when you take your work to that country, to the US, you already have some sort of recognition. So if anyone did anything, you'll be able to say, oh, you know what, actually, he's even recognized in our database, and he's an author, and he has basis. So you over there, maybe it's a hotel, you'll be able to ask them to assist you with such issues. So, it's about the countries of commercialization, which is very important. Protect where you're going to be present, or where your work will be present. Yes.
Okay. So now I'm a visual artist, for example, or even a musician. I create 7 pieces a day, if that is possible. How do I, does it mean every song has its own, how do I put a series of work in, how do I copyright that? Otherwise, half my time, instead of producing work, I will be copywriting work.
You can do them as collections as well. So you put them in a folder. So when you go onto the website, you are able to upload different formats. It will tell you the kind of formats that are possible. So you find that, even, like, for example, a PDF is easier. So then you can have your images. Page 1 is the first image, page 2, like that. Then you give it a name as well, because the certificate needs to come with a name. So depending on where you are, or your creative space, you just come up with an interesting name.
So for example, Leah, who is asking about a book, how does she puts the whole book up? Or does she has to put the whole
she puts the whole book up, especially because you see, after she's created it, she's likely to engage a publisher.
Yes,
right?
Indeed.
In that process of engaging a publisher is quite interesting, because it means you're taking your manuscript, and there'll be changes and all that. So you always want to have a reference point to the original.
That is true.
Because the publisher again might come and say, I've done too much, now it's mine. What basis? So you want to always say, I have a copyright, a document, here it is. Now we see, even in this space of the publishing sector as well, there are other things you need to take care of. Because remember, you're engaging with powerful businesses. They have the financial power. So you want to protect yourself. So as soon as you register the copyright, it doesn't stop there.
Yes.
The minute I bring you my book, I make them sign a document, a release document that says, on this day, I came to Kathy Publishing, I brought my manuscript. We have agreed that you need 3 months to review my manuscripts. Within 3 months, I have feedback, and I come back for my manuscript. You accept that you shall not duplicate all those smart things. All those things you say in that contract. It's a very simple format document, but it has everything. You have walked in the shoes of that publisher and the kind of things they would do. So again, here, you don't self-lawyer. Find a lawyer who will do something proper for you.
That's right.
And they can even they play the bad guy on your behalf, so that you can continue looking and creating and being nice. Let your lawyer shark out for you.
I think as an artist myself, I think if not being lazy, I've got to know what my rights are, but it's always safer if somebody else is dealing with, because the hustle of chasing copyright infringement and the rest, it's always nicer if somebody else does that.
Exactly.
And then, I can keep in my space where I am free to create with the dignity that, a contributing taxpayer.
Yes, exactly. Artists speak of themselves as a business.
They are a business.
So you remember, in any business, we're not Pekiako production.
No,
you have an accountant, you have a marketer.
Exactly.
So with your kind of business also, you understand.
Exactly.
I'm an artist, I know digital has now become
That's
a
right.
thing. So maybe I get a digital marketer and then I tell them, oh, when you're digital marketing, you're always looking out for where my work is being used. Flag it, take all the evidence you need to take, screenshots, all those things, put them somewhere in a folder. You take them to a they proceed the rest of the process. Yeah.
Thank you,
So, but always create that.
Thank you. I like the fact that as artists, it doesn't mean that because we have lawyers, we don't need to know the law.
Yes.
We must always know the law so that even by the time you're approaching a lawyer, you're coming from a place of knowledge and not, oh, help me, the ship has sunk. But you know what you're coming in the same way as you say, a business person, an informed business person would approach a lawyer.
Yes.
Yes. Thank you very much. I think we move on to the next question, and this is from Dan. Now, I'm going to paraphrase what Dan has asked because it's very long. Now, Dan is asking, when collaborative works are made, when are there two or more people who are involved, when there are two or more people involved in this, to whom does the copyright belong? And Dan did not specify which art form he is addressing, nor did he, talk about who invited who, or, it's a very open, ambiguous question. I'm sure you knew what you meant, Dan, but it's not clear to us. So please.
Yeah. So first of all, if we're going to work together, co-author a work, we become co-authors.
Co-author.
We are joint authors.
Yes.
We each have a stake in the work. Now, our greatest challenge in our industry is we never have these conversations in the beginning. We just say, hey, I need to collaborate, collabo. Yeah, and then we don't write anything. Then even we do not figure out what we're going to do with these collaborative works because you have your circles, I have my circles. I might go and decide to morph it into something else.
Right.
Now here we're talking about copyright derivative work.
Exactly.
We needed to have an
copyright
agreement
what?
Here. So derivative work,
yes.
We created something together, right? And then I decide from this original we created, let me now put it another flavor that I have and create something different, but still borrowing from the original. So you see, I created derivative works, but inspired or even borrowing from the original.
Okay.
So this original agreement needs to dictate, now we created this work, what is our plan on this work?
Yes.
Based on this plan, we have, if I created something else on my own, can I do it under this contract? Correct. Yes, no. If I can, how do I do it? How am I paying you? And even in this original contract we talked about, what is my contribution, what is yours? Are we 50-50, 60-40, 20-30? We have to have that conversation. Then now we put together a contract.
Because I was going to ask, is all this in the Copyright Act? And no, it means whatever, even as artists, we must come together and whatever we decide, it has to be in a contract.
Exactly.
All right.
Yeah, so and we need to stop thinking that we need a law for everything. Because the law gets into this relationship. That flexibility for us to decide what we want to do will be interfered with. That means even your artistic process, my artistic process will also be curtailed. I'll always feel like I'm in a cage. You don't want to do that. Contract law is very fluid. It's about what you feel, what I feel, and then there are those basic parameters. It shouldn't be based on something illegal. All that's the basic balances. But everything else is between me and you, right? So you don't want the law to interfere with that. So when we co-author, we have to have at least that basic contract.
Yes.
Then it will always be the reference point if we want to do anything individually based on the same work.
Okay.
Yeah.
Fantastic. So now, when we're going back to his question, let's try and use it in a scene of music so that it's a bit clearer. He didn't specify, but we can use now. You and I are going to collab on this music thing.
Yeah.
And I'm saying things so disrespectfully, but we're going to create a music piece. I will write the words, the lyrics, and you will do the beats and
the melody.
So and then
Yeah, so let's start with, if we're talking about music, we realize first we have what we call copyright and related rights in music, which is always important that our artists understand.
Yes.
Yeah. So copyright is the author of the copyright in music would vest with the author of the song, so who wrote the lyrics, and the composer who composed the melody. Because sometimes I can have the melody, I'm like, I play it on my keyboard, and then now you come with lyrics. Yeah. Right. So you write some lyrics, you're a poet. Exactly. Use them together. Exactly. We've written together, right? That is right. And then there's a person called an arranger. Who will arrange the music, the sequence. They will tell you, oh, rap here, ad lib here.
That's right.
You know, piga vigelegele hapa.
Correct.
All that stuff.
Correct.
They make the music colorful.
Yes.
You find these three parties. Can be one person, can be 5 people. So depending on all these parties, we have a conversation, and we have what is called a split sheet. Split sheet. So the split sheet will say, we have author, arranger, composer. We agree. Sasa wewe composition yako ilikuwa 20%, 100%, 50%. We agree. You know, based on what I did and what you've done, I think mine is 50%. I did the chorus. I even did what, you know. So we have that kind of negotiation. The copyright, we're talking about 100% of it. So that's how we are negotiating, not over 100%. On the composition, I did 50%, maybe. Right. And then on the composer beat, maybe 20%. So it's that negotiation at the end of the day, because we're the ones who know the kind of input each other has put into creating the work. So that split sheet is also what will guide when revenue is being shared. If money comes through, we are able to say, okay, we've gotten 100K, our song has been used by some certain corporate on their advert. Right. We said yours is 20%, okay, yours is 30%. Right. So now we calculate out of that 100K, everyone has their share.
At the end, who owns that copyright now?
So here, it's these 3 parties. So which means if I commercialize it, I will have to compensate the other party. And if you do the same, you have to come and tell us, I made 50K, and we share it like that, right? This is on the song. So just the song, before it goes even to the studio. So we came up with a song, and maybe someone had it, and they said, oh, wow, we can use it in an advert. We can use it it can be a jingle in a movie or whatever it is, right? So this is just the song before even the beats have come in place, right? Before we enter the studio. Now, when we enter the studio, related rights now checking. So with related rights, we have first the performance. So here, performer, we'll have the guitar guy, the performer. We will have someone, I don't know, playing the keyboard, the performer. Maybe someone else after we've written this song will come and sing it. Now he's a performer because
the person on the mixer.
So then we're getting there.
Oh, not yet. Oh my.
So there's the singer.
Right.
We might have the background vocalists as well. They are also performers.
Right.
And then now there is the track producer, the guy behind that fancy machine. Because this fancy machine now replaced the guitar, the drum.
Exactly.
I just press ding and yeah.
That's right. You get it.
So then I've been imagining that someone producer. So that is also he's a track producer, but he's not a producer, because now that leads us to the second related right. The producer under the Copyright Act. Under the Copyright Act of Kenya, under the copyright all over the world. The producer is the guy with the money.
With the money.
So this can be either you're feeling rich,
yes,
you want to sponsor us to do a song, you give us some money, you go to the studio, you become the producer. Alternatively, the person who owns this fabulous studio,
yes,
might say, you know what, pay me 20,000 just for studio time, because it costs 50,000 or 100K for you to own the master recording. You can't pay.
Yes,
I'll take care of those costs, but then I'm producer now on record, and I have the producer right. Again, we don't have that conversation in our industry. So we're always paying like a 20K here, a 5K here, and then we're imagining we own the master rights. No one is having that conversation.
Exactly.
So you're a businessman, you understand this business. You're like, well, how can you think 5,000 is owning the master recording, you know? Right. So, but then we don't having this conversation. You assume, this one has assumed. So it goes around telling people that is my master. You're here, you're like, 5,000, no, studio time. You know, so and again in our Copyright Act, it has to be in writing.
Yes.
So if it's not in writing, it now becomes a game of he said, she said. Again, when I give you the 5,000, did I give you a receipt? What does the receipt say? Ambiguity. So then now that becomes a whole mess.
So are you saying that here's yet another example of how you must have a contract.
Exactly.
You must in
must have
writing.
yes.
What are we agreeing?
We have to have that contract. So
Right.
you have pre-negotiated with the studio.
Right.
They told you 5,000. You say, hey, 5,000 ni anini. What am I getting from that 5,000? We negotiate. Say, okay, can I add another 5 or 10K?
Mhm.
And I own the master recording.
Right.
Tumekubaliana, yes. Have him sign.
Right.
You know?
Oh, wow. I hope that what we're discussing here today is actually very clear, or is answering some questions that we might have about some of the things that we do. Because what we're talking about here is our daily practice during our creation processes, and that sometimes end up putting us in a place that we really don't want to be. So I hope we are answering some of those questions as we go along. Do continue sending us your questions. I have yet another question, and this one is, I pitched. It says, I pitched a pilot program to a broadcasting house, and even after signing a non-disclosure agreement, so there's the contract, they said no, they didn't want my idea, but then they stole my idea, created their own show, and now I am frustrated. What's your take on this?
Hey, first, I think it's important, especially in the film industry, we need to start talking to each other. Mm-hmm. Right? Mm-hmm. I need to share my experiences and say, I worked with broadcaster X, this is what they did to me. You share the same, because again, we are able now to figure out what needs to happen there.
Okay.
Now, a non-disclosure agreement is that document that basically says that I am disclosing an idea to a receiving party.
That's right.
That this idea sometimes may not be fully developed, or be more conceptualized, but I have done my research. There's been input that I have done. So it's proprietary information. It may not have space in copyright, but there's some input there. So you're basically safeguarding it under that non-disclosure agreement.
Okay.
But this NDA has to be signed before the disclosure. That's the challenge that people do not understand. That I want to tell you first, here's my non-disclosure.
Right.
Read my terms.
Right.
Are we on the same page? If you are not, you need us to negotiate.
Right.
We negotiate first this
before
arrangement. Before I come and I give you all my fabulousness. Exactly. So if you decide to do that after the fact, this is what happens. That is now the product. Because now I'll be like, now you're giving me an NDA after. I mean, this is my ordinary course of business. How are you going to prove to people that you brought this information to me, and this is what I do every day?
Exactly.
Yeah, I'll be able to say, oh, you know, by team here, I have a script writer from Hollywood. I have one who's worked in Bollywood. You have had one who's done this. I have one who's even a teacher. You know, so how do you think you're the one? You know, so that NDA you want to sign before anyone who writes an NDA is going to be a dishonest person. So already that should be enough of a red light for you, so that then you decide, will I pitch despite it? If I do, I am aware of the consequences. Correct. So that tomorrow I know I'm the one, I dug my grave, you know, so let me deal. Or I walk away and I say, what I have created is just too precious to me. It's okay. You don't want to sign my NDA? Misawa, I will deal with another broadcaster or another investor.
I think another thing that puts us or makes us a bit unsure of whether I have copyright or not is because we're usually talking about things that are shared experiences. So I'm busy saying, Catherine has 3 dogs, and dog A does what, dog B does what, and then dog C does what. And then I see a TV show which says now that Liz has 4 dogs, and then I say, Liz copied my idea, without also saying that there are some things which are common life experiences that we can't say so and so stole, because it's a way of life. And I think a very good example is that when we say, you know, rich man dies and then now he has 5, 6 wives. So, you know, that's a story that has been told in so many different ways. So as you said in the beginning, it's about the expression of that idea that is copyrightable. Exactly. Isn't that so?
Yeah.
Great. So then this person continues to say, what do I do? How do I go about pitching my pilot series confidentially in a safe environment? I think that's what you said, yes?
Yes.
We give the non-disclosure first,
Yes.
and then negotiate whether we are both comfortable, and then move on.
Then it is signed.
It is signed.
And make sure it's signed by the relevant people, especially when you're dealing with corporates. Yeah, it has to be signed by someone who has that power under that organization to sign.
Right. How would you know that?
You have
to
do your homework.
diligence.
You have to do your homework.
Okay.
You remember a few years ago we had an instance where now it wasn't really a script,
Yes.
but it has something to do with just the issue of always signing with the right person. This person decided to go shoot a music video in a certain franchise establishment,
Right.
and the person they were negotiating with, he didn't bother to ask who or she was.
Yeah, who are you?
They were like, yeah, I'm in marketing. That's all they were told. I mean, marketing.
Yes. Right.
So they agree, she makes concessions, they have a conversation. I don't think they signed an agreement per se. But I think they didn't sign. But anyway, everything, systems go. Everything was done. Even the day for the shoot, they were called and they said, yeah, we're waiting for you guys to be here at 11. They even agreed your artist will wear our uniforms and do this. You know,
right?
That's the production, investment, everything. Please, on the air, there wasn't a contract. So, out of the kindness of his heart, he said, let me take it, they review it. Just, we're on the same page, you know. So now when he took that to them, when he knows everything is good to go, he gets a call and he said, hey, by the way, my bosses have said no. You've already spent money.
Oh my.
So you want to deal with the right people, especially with big corporates. Make sure you're dealing with the big people. You ask, can you sign contracts? Can I, an email from legal or whatever, but I have to be aware to know that you have that authority before you lose that investment.
Indeed.
Yeah.
And especially when shooting videos or whatever it is in a certain location that does not belong to you, you do need a signed location release form.
Exactly.
You cannot proceed with that without that. And those are the contracts that
those are the contracts
about.
And then you see also with that kind of arrangement, again, you're looking at what is the location, who is the owner of the location, are there any special issues that I need to pay attention to? So, because for example, if I wanted to shoot in the Masai Mara, I need a license there. I would a simple location agreement won't do, because I have to go to Kenya Wildlife and understand what protocol is there in place. Do they have their own in-house contract? Do they have do's and don'ts? All that stuff. So when you're doing your recce, you do all that stuff, so that then you also make an informed decision. And then you're aware this is the kind of due diligence I need to do, so that tomorrow they don't tell me to take down my music or my film.
And supposing I'm shooting on the streets of Nairobi, that's public land, is it not?
It is, but you still have the county to deal with now. So now you have to go to the county offices and explain that you're shooting a film, and then you have a certain document that there's a license you have to take out. Fantastic. Then remember, you have to go also to Kenya Film Classification Board for them to review your work before you get another license from them. So
no, let me understand this. I'm trying to put my work up on YouTube. So it's simply record the thing, upload. So what are we saying?
So we are saying,
yes,
there are so many rights that coexist in a piece of work. So now, like in this instance, we're talking about an audiovisual work.
Yes,
like a film or a video.
With my music, it's my latest music video.
Exactly. So if it's a music video,
right.
Remember first, I have a team that I am working with.
Yes.
How is this team coming into place? Now in copyright, we have what we call the doctrine of commission works. Or work for hire.
Work for hire. Very good.
So now,
what is that?
Victor or so and so is good with the camera.
Yes.
I don't know. Example, Enosolic is very good with conceptualizing music videos, right? So I have a conversation. Yo, Enos, how can we work together?
Correct.
We have a contract.
Yes.
So that it's clear what it is at the end of the day. He's a popular video producer.
Okay.
And for him, the kind of creative input he puts, he's attached a value to it in a way that sometimes he can get co-ownership. Okay. So you have to have that conversation, because you need to understand the mode of operation, the people you work with, so that then you have it on contract.
Right.
At the same time, you're like, okay, I want it on my channel. So you say it there. As much as maybe we co-own the video production rights, I want it on my channel. So in the contract, you say it will be on my channel and not yours. But when money comes, that contract says then because I only paid you for the labor you did on that day, and we've agreed we are owning the rights to the music video,
right,
20, 30, 40, 50, whatever it is, we agree, right? Then anyone else now, that like at least I should be able to pay off. Again, remember, you can't always be sharing royalties with everyone. It's such a headache.
Correct.
You can't have 100 people.
Yeah, in fact, it's beginning to sound so complicated. I'm like, do I really want to make this music video?
Yeah, exactly. So like those people now, you just hire, they do their work, and they go. So the guy on the camera comes, does his thing, and they go. And all these other people that will, the technical team, you've hired them, they sign a contract, work for hire. So even if, because, I'm so good with lighting, I figured out, this shot, we can do it like this, alafu a shadow will come, blah, blah, blah. You don't start saying, I have copyright. Like,
because it was a work for
hire. So that just came up incidentally, you figured something. So please do not start claiming, I have paid you 50K. Thanks. Those conversations need to happen.
Right.
So that then when I go online, they don't come after me again.
True.
So that is those guys.
True.
The models you will use in that video.
In the video.
You also have to have contracts with them.
Exactly.
Right? And then disclose, you're my video vixen, my video will be on YouTube,
thank you.
broadcasting,
Indeed.
all that. Because there we have this thing, it's not copyright per se, but we call it image rights. So with image rights, if I'm using you as a video vixen, we're talking about your publicity, right? Because that's what you do. It's how you make money. You make money from your image.
Exactly.
And then now if it's just on the street, a guy passed by, we now need to be aware of, now it becomes issue of privacy, a privacy right issue. So now you have to be clever with it. If I'm going to show your picture and you're some random stranger, you're going to appear in my video, then I have to talk to you. We agree. Am I going to pay you? And whatnot, we have a contract. So I'm not going to pay you, but I wanted a busy street and whatnot, and I show people's shoes or something. So I'm taking care of the people's privacy, but I'm trying to, I want my audience to know I was in the busy street of Nairobi, then I'm taking shots of Kibera, I'm not Kibera, Biashara Street, that's a sign. That's why, again, that license from the county is important. And then subsequent, because like in the film industry, we have the Stage Police Act, where the Kenya Film Classification Board has to also be aware you're shooting some audiovisual work. And because they will classify, the initial step is that they want to review the work that you're going to showcase or you're going to shoot. So then that they stamp it and agree. So that now when you come back for classification, they have you on file already that you did this work.
We're aware of this.
We are aware of it. So now we are now
related.
classifying it. 15 years, 20 years, not suitable for underage, all that stuff becomes important, right? If you do not do this again, that is another offense and a different act, now the Stage Police Act. So there are so many rights that usually tend to come in, and they will evolve with the kind of creativity and ideas that the person is shooting have. So these are just some basic examples.
Indeed.
Yeah.
Indeed. Now, and it's good you've talked about that, because I'd like to know, this another question that has come in is saying, a corporate organization has commissioned some work from an artist. This has been created, paid for, delivered. The artwork somehow gained some popularity, and then it starts generating income that nobody had ever seen coming. Yeah? What are my rights as an artist now?
So with commissioned works, there will always come a contract. Then the contract becomes very important. So the contract will state what rights am I relinquishing, or am I relinquishing is a fabulous legal word. I am giving up, basically. Yeah, because when you're commissioned, you give up certain rights. So in the context of copyright, I have commissioned you to paint something for me. So at least now the contract should be your guide. What is the plan? I'm the author or the artist. I need to also be smart. When I'm negotiating, I want to know, okay, you want me to do a painting. What's your plan with the painting? You want to do an advertisement, or you want to put it in a public space, or what? How are you making money from it? I understand that scope, so that then I'm able to have a preview of where this work can go, right? Then I know what I can negotiate for. Now, if you end up signing one of those very blanket contracts that say I take this in perpetuity, and perpetuity means forever and ever, some crazy other, you can never do derivative work, like you can't or repaint this work, like all that stuff. You need to be very careful. So this is one of those things that it's the contract. Excuse me, it's the contract's about the offer on the table. So based on that offer, what are you agreeing to? Then you'll be able to be in a position to see what else can the work bring and how can I protect myself or negotiate and say, you know what, should this happen, then you will further come to me and we have a negotiation, or we will work together, or you know, should you exceed X amount of money, then you compensate me some more from the more money that you've made. You know, like have that provided in a contract. So it's extremely contractual.
But is it wrong if, for example, I create this thing that's beautiful and I sell it? I'm very happy with the money that they paid me. And then whoever bought it, for whatever reason, they made extra money on top of it. Is it wrong for me to feel, you know, satisfied?
So be satisfied with what you have
with what I've already been paid?
It's fine, because at the end of the day, when you're negotiating, you also want something that you will get an offer that will help you sleep at night or make you sleep at night.
That's right.
I'm like, yeah, I made 50,000. I'm easy, you know.
Yes.
Not for I made 50,000, but
yes.
Now what brings all this?
And you see, even when we're talking about 50,000 these days, the kind of monies that are being spoken about are in the millions. So you see, I'm thinking if we've finished with a contractual arrangement, you've commissioned work from me, I've been paid. Okay, I know the Constitution was the Copyright Act was amended to talk about after sales.
Yeah.
So what is that?
So with especially on the audio, sorry, not audio, artistic
visual arts.
So yes. Especially the paintings.
Yes.
The resale, because art will change hands, right? So and then it sometimes it appreciates.
Yes, resale, not after sale.
Yeah.
Yes.
So yeah,
yes.
resale.
You're right. Yes, you're right.
Yeah, there's so much copyright.
You mentioned,
but yeah, it's the resale, right?
Yes.
So go down buys our paintings.
Yes.
And then 5 years down the line, a certain embassy says, "Oh, I love this work. Can I buy it?" And then we bought it for 5,000 Kenya shillings, and now it's being bought for 1 million. Right. So now the author under this new right should be able to get now the resale right, where they will make some certain percentage from the amount of money you have made from reselling that art. Right. So, but now with it has come with those challenges of how do I trace the work? How do I know? Do we start thinking about attaching some sort of technology so that the author can always have a dashboard somewhere and they can see, oh, my painting from 1992 is still going around, and
that's right.
Like those are the conversations now we need to figure out in terms of what that will
because even as a visual artist, we'll say, does every visual artist know whom they sold their work to and at what price? Exactly. So that if it is resold, they can actually have legitimate claim, or at least have an idea of where to start tracing the work.
Exactly.
Right.
So they're the kind of systems we need to put in place. We really need to think about them and figure out how that would look like. So it's not only just a Kenyan challenge, it's an international challenge. Those are the conversations that are happening. And of course now the collaborations with people in science and tech to see also what else can be done in regards to that.
Right. Thank you. We're getting quite a few more questions. Okay. Let me just get to the next one. Please do continue to send in your questions. We have a bit more time and we can actually work with you on this. Now, apps, because that's the question. I'd like to create an app. I'm creating an app and I don't know how to go about getting copyright. Okay.
So remember, the authorship vests with the creator, right? So the software developer is the one who will own it. Again, so who is the software developer? It might be me as an individual or my company. So if it's a company, then my employees will have to have a clause in their contract where they relinquish all their IP, they give up all their IP rights to this software because it was developed during their course of employment.
Right.
So then now when they leave, they will never say, oh, but I left, Liz Inc. Incorporated owns, they stole my copyright on my software as an employee. So that needs to happen. And there's me as an individual as well. I own it, right?
Yes.
So I can go and copyright, register the copyright to the source code. So the source code is, when a software is being created, there's this, it's an interaction of all these symbols we see on the keyboard.
Right.
Letters,
Yes.
all these exclamation marks,
Correct.
crescendos, blah, blah, blah.
Yes.
So they will do certain things and give a certain outcome. So I could do A147 underscore something to do something else. And someone else will do underscore 4512, like just different organization of what my initial code is, right? Again, expression. So
Correct.
for us, we copyright software. We do not patent software like America. And sure enough, Americans are kicking themselves right now because it's become a very expensive affair for them to create further software and apps because of this patent system that they have, right? So claiming that novelty for them wasn't a smart idea and approach. So for us, copyright, because how you will do it will have a different execution or command from what I will do, right? My combination might make a cartoon dance. Your combination maybe is to shoot in a game, in another game. You get? So that's the expression. So whatever I have created, the minute I do that, I will register it for copyright as well. So all those you see, you will print it out or you put it in a document, and then that's what you will register for copyright. And then there will also be a description that this is the source code, this is what it will do. It is for a fighting game. It has the following elements. It can dance 2 steps, 5 steps. One cartoon dances 6 steps to the right, can do a flip, like that whole description, right? Correct. That's what you protect. Correct. Now, the interesting thing for us in our market, and I think even globally, is that now this is a skill set for very few people, or a knowledge acquired by very few people. So I have a fabulous idea for an app, but I have no know-how, right? So I will go to someone else and I say, oh, I heard you're a very good software developer. Yeah. So again, now we have a conversation. What is your rate? Because of the kind of work I've done, you pay me 500K. Yes. Yeah. Can I afford that 500K? What am I trying to put together? Yes. Yeah. So all that. So if I can afford, you're like, okay, fine. I'll pay you 500K. This is what I want you to do. Exactly. I have told you the creative what I expect, and you treat it as a work for hire. So any IP belongs to me. Correct. You only retain. Again, I didn't talk about moral rights, but at least you keep your moral right, which means you'll always be remembered as the author, recognized as created attribution. Exactly. Yes. That is one thing that we cannot take away, regardless. Yes. So even if I'm employed. Yes. Right. You will always do it. By Kathy created this. That's how they cannot take away from you, and you can sue. So that because it's provided for under the copyright. Right. So we have that conversation, and it's clear. I paid you 500K. I own the software. So I go commercialize, make my money. Thanks. You have no claims further than that. That's right. Now in the event where I cannot afford, yes, because 500 is not little money. Yeah. So in the event I cannot, now we have a conversation. Do you want to be a co-author or co-owner? Yes, no, maybe. Let's get on the same page. This is what I want you to create for me, but this is what I want to do. I am in marketing. I can find the market for it. I am trying to create something different, whatever. Like I am the vision bearer, right? But you're doing all the heavy lifting because So we have that conversation. Yes. Some will say 50-50, some sort of percentage. Yeah. So you have that negotiation, and then have a contract. So now here we're talking about more about co-authorship, joint venture sort of arrangement. Then we have it on agreement, and we agree because of the kind of work I'm doing, you're only the tech, so you're not in the decision making part. So that's where I was going next, So you're just tech. So every time I make money, I give you your 50% or your 30%. But you won't say what I can do with this. Exactly. Right. It has to be the contract. Okay. We are very clear of what kind of authors we are or what kind of partners we are. That's right. Exactly. So that then there is no issue. Yes. Not having those contracts. The project is almost 70% done. And then I say, hey, Kathy, you did sign my agreement. Kathy is like, hey, the work I have done.
Exactly.
Hey, Kwanza, now you owe me 90%. I'm 90% owner. So, and you see, because you're calling the tune because you have the expertise.
That's true. That's true.
You know, again, contracts are signed in the beginning.
In the beginning, I think as artists, we're very reserved about contracts. They sound so complicated. They sound so time-consuming. And after all, we're friends, Liz. So why do we need something, written? And yet, tunaelewana, and I think it's a good discussion that we've had today, which shows us that just because I have a contract with you doesn't mean you're not my friend. And it's putting us all on the same playing field, level playing field, where I know what you expect from me, and you know what to expect from, and I know what to expect from you, and vice versa, right?
Exactly.
Now, there's a disclaimer that I would really like to put here. Coming up, please give me a moment to find it, because we need to be very clear that the advice that we're giving here does not constitute legal advice.
Exactly.
So,
this is purely for information.
For information, yes.
It
So
does not constitute attorney-client relationship or privilege.
Correct. So you can't go to court and say,
exactly.
Liz and Kathy said no. Very true. Very true.
Yeah, so anyone who feels even like that, something they are related with has been touched on,
Yes.
they need to find independent legal advice.
Exactly.
So that's important.
Exactly.
Don't say at least it's your lawyer. You've not come to my office.
Sure.
I'm not on record representing you. Neither is Kathy. So this is purely information and entertainment.
I think that one of the most confusing or things that is difficult to grapple with is that copyright law is so case-based, because two things might sound so much the same, but in one case there's just a slight thing that changes the whole outcome of the whole process or the direction. Exactly. And whether your copyright has been infringed or has not been infringed, and then also whether you're going after the correct person or actually you should be going over after somebody totally different.
Yeah. Right.
So in your experience, Liz, because I'm not seeing any other. Okay, here we go. Someone copied my song. How do I go about reporting it? And appropriately and approximately how long will it take Kekobo to get into action? And that's I think from you.
That ownership, was there some registration of some sort to begin with, or were you the first person to put it online with a timestamp, with some sort of evidence that it originated from you? That's the first question we need to ask ourselves, and then confirm that, because that is what then we use to go to Kenya Copyright Board and say, because I am a citizen, I cannot arrest. You are the body in charge of copyright, and my song has been infringed. Here is evidence. My YouTube page on 14th February 1990. Let's say 2005.
Yes.
That was before. So February 2002, 14th, I put on my YouTube or whatever. I put this song, and here is the song that is playing on radio. Here, and then they're able now to assist. Now you officially lodge a complaint, and then now they will assist in figuring out how to pursue this particular party. But that's on the criminal side. There's the civil side, right? So with the civil issue now, is where you now look for a lawyer, and you say, so and so has sung my song without my permission, and then you give it that the same information you will be giving to Kekobo for me also to make sure I'm doing the right thing, right? I have proper information, so all that disclosure needs to happen. I ask all the questions, and then from there, I ask you, are you willing to have this settled out of court, or is it your position to fight to the bitter end? I will educate you on both possibilities and what you should be aware of and what you should prepare yourself for, and then from there we devise a strategy. From there we will start with the basic demand letter, and then we ask for payment or ask them to come to the table, and then now we start conversations around that. If they're too stubborn, then now we can proceed to court.
Which it goes to say that in the case of copyright law, it is the aggrieved who actually has to do the legwork to prove that actually something has, or their copyright has been infringed, something has been misused, stolen, vandalized. So it is actually the aggrieved responsibility.
Because copyright first is a personal right.
Right.
It's an individual right.
Mm-hmm.
It rests with me as a person.
Mm-hmm.
So because it's mine, it's up to me to police my work. It's up to me to know what is going on.
Mm-hmm.
It's like having a shamba, my own shamba.
Yes.
I put a fence. I'm always going to check. I have a watchman.
Right.
If someone decides to throw a banana peel and I can find them, they have littered.
Exactly.
So you figure out, under the different laws, how else
Right.
they can,
Yes.
you can, help yourself. If they decided I'm feeling adventurous, I can walk using the public road, but now I decided I can high jump. So I want to high jump through the shamba. It's trespassing.
True.
So it's the same thing with IP. You have to know, you want to know when someone is trespassing, quote unquote, they're using your work and all. So it's personal. So you have to really be active.
Right.
So if you don't do it, no one will do it for you.
Indeed.
Yeah.
Which means that as a copyright holder, if there's a work that I am trying to produce, it is important for me to document the process of me producing that work, because that will count as evidence in a court of law.
Exactly. Yeah.
So every step I take, if there's a few camera pictures and a video recording of how I'm going about it.
Yeah, especially for artistic works.
Right.
Artistic works, sculptures,
dance,
the movables, even dance.
Yes.
They're those ones you really, that's what you want to do, so that then there will always be some sort of evidence.
Very good.
And now something we need to talk about is content online. So people tend to think because it was on the internet, it's free.
Yes.
Oh, I saw a picture. Oh, it's free. Put it on your presentation. Put it in your book. And then sell your book.
Yes.
No, it's not free. The due diligence needs to happen when you're getting images. Because like what happens when you go on Google,
yes,
you will get the thumbnails and whatnot. So you press it. And then you follow the further link and see where they get this picture from, or who is the picture, who is using it.
Correct.
And they asserting ownership to it or whatever it is. Like you have to really dig deep. And at the end of the day, if you see you do not know who this author is and you can't get in touch, then you know, this one, I'm going to use I'm going to get to, create a billboard. I won't touch this picture because heavy investment. I'm not sure that I have the copyright. Is there a picture of a model you need? I don't know if that picture, who's the model, have they been clear? What kind of contracts have they signed for this picture to be,
That's right.
So because of that, be very careful. All these platforms for stock images, read the terms and conditions. Because they have very specific terms and conditions regarding the copyright, the image rights, and all that.
Yes.
Make sure you're on the same page. So that also when you're paying, don't think that you paid for everything.
Yes.
Yeah.
Exactly.
Some of them, they're like, they paid the photographer, but the model in the picture probably doesn't even know they were on that stock image. And then you go and do a fabulous billboard, So it's important that those rights are clear. Now, in the event that you're more in the academia space or you're a knowledge share kind of person, we have the Creative Commons license and platform. This is where now we have different copyright authors and owners who contribute their work under the Creative Commons license. The Creative Commons license we have those two, like there are 4 images that are usually going around, and then the double C around.
Double C, yes.
So any image that you see is under Creative Commons, again, those images are the terms of the license. So you will see that little man or the shape of a guy. It means you must attribute the author. Yeah.
Correct.
Then you see that round thing with an arrow. It means share alike. So you can share in different platforms with exchanging ideas or whatever it is on a blog. You can hyperlink because it's a source of knowledge. You're good to go. Then there will be that sign. I don't remember that for non-commercialization.
Yes.
So which means you cannot commercialize.
Yes, you can use it, do what you want with it, but you cannot make money.
Yeah, and when you're in doubt, you're better off contacting the artist or the author before you use it, so that then it's expressed. Because there's some things that they are borderline commercialization, not for profit, that you're not so sure. So it's only prudent that you also be a serious person and respect those wishes. The good thing is also for the Creative Commons, it also builds artists and authors' reputation. They get to be seen, right? Which helps them to get more work. We don't have many Kenyan artists, authors, generators of work contributing their work to the creative license, to the Creative Commons. Yes. So we need to do that more, because the more we do it as Kenyan authors or as Africans, we'll get more work. We're not asking ourselves, we're not asking ourselves, why is it when there's an African themed movie being done, it's a foreigner scoring the music, and yet we are the ones who know what that African vibe is,
the feel, yes,
that can drum is away, exactly,
yes,
who know. So, but why is it? It's some foreigner who's getting that one, because they don't know our people. Our people are busy just dying also with yangu, because we are now just discovering about copyright. So we're really starting yangu. I got it with my life.
Is it because of past experiences?
I think so.
Because I think we've been taken for granted, pinched. So we've become so defensive without realizing that if we let go a little bit, the markets actually open up so much better for us.
True. And we need to just observe other people in the industry, other cultures, how other people are basically creating opportunities for themselves. You find that they are the ones who are always ready to take a picture here, put it on Creative Commons or whatever it is, and say, use it, So they are free to give, so that then now a corporate someone will always remember, hey, that photographer is very good. Wow, that documentary, we have to call that photographer from Nairobi. Yes. Call him back. So
are we saying that Creative Commons is almost like an open portfolio for me to put in, samples? This is a jingle. I've given it to the world to use in a certain way for free, without having to ask me. But it's also a way of saying, excuse me, here I am, and I know how to make jingles like this.
Exactly, because you don't have that little man on your license say attribution songs by Kathy, so that everyone now will be like, Kathy can play drums, bass.
That's true.
We have a film, Kathy's song will feature, or she will write a song for us. That's how you get known. So even on the TikToks, because it's a widely used platform.
Exactly. If your jingle is on a TikTok,
you're getting exposure. And it's just entertainment, right? So you're just share a like. Nobody's going to use it on an advertisement or whatever, but people are just having fun with it. They're sharing it. I'm telling my friend. My friend does another video. So that social conversation is happening, and people are always having your name at the back of their mind. Exactly. So when even an ad agency is contracted, they will say, this is the client brief. This is our person. You're on a database.
That's right. Thank you, Liz. Liz, I don't know, what is your experience in artists approaching lawyers about copyright? If we can just remove this. What's your experience?
Sorry,
about artists approaching lawyers?
Yes. So for the longest time, the industry, first of all, the industry existed without us for a while, because they imagined that we don't need lawyers, which is a very common, misconception. And I think that approach sort of contributed to the fact that for the longest time, the creative arts wasn't taken seriously, because at the end of the day, you just go entertain people and they're like, people are not embraced structures. Then now people realize, there's money coming in, foreigners are also coming, they're looking for structure. So then we realize, we have to start embracing structures. We realize, we have a Copyright Act, so with all these developments now, the need for lawyers has been there. So the fact that people imagine that lawyers are expensive is also a misnomer.
I think they were.
Yeah. We are the expensive when there is a fight.
When there's a fight,
we're expensive. Because why is we expensive? Because we absorb all your hearts. All your drama, we fight on your behalf.
Isn't that the reason why the creatives are like, you know what, my artwork was infringed, my copyright was infringed, fine. As opposed to approaching a lawyer, the costs are so high, it's tedious, I'm not sure where this is going, I'm glad to say that of late, there are very many lawyers who have come up who are very interested in the IP and are trying to see the law through creatives' eyes.
Yes.
Because creatives, it's not that they don't know what is right and wrong. They do. They don't. It's not that they don't know when their copyright has been infringed. It's just that because of who creatives are, the tedious process of having to walk into court every other day, we're discussing with the lawyer, we're fighting about money, we're, that kind of thing.
Yeah.
Has law changed so that it can accommodate, and not even accommodate, but respect the different nature of creatives?
Yeah, we're slowly evolving, especially on the legal side, because, like you said, more lawyers are opening up to this space, and there's a way as artists we like to do stuff. There's a way we like to be talked to,
That's right.
to be related to. So lawyers are now embracing that, and they realize that, I need to be in a relatable space. I can't, siezi nyongatai, I look like I'm about to suffocate you.
Yes, and even if you do, your attitude towards me should reflect, that respect.
Exactly.
Yes.
Because that's what also helps, because now we have seen a lot of growth of mediation and arbitration in the industry, and especially mediation. For me, especially, we rarely go to court, but it means that I also have, as a lawyer, I temper myself down. I walk in the shoes of an artist. I think creative lawyering is what we call it, right? So that then I am not saying, oh, your only option is going to court. Court is the last option. Right. We have, there's this popular saying, intellectual property has a shelf life of a banana. So if we're stuck in court, and court takes years, 2 years, 4 years, 3 years, we are fighting a song here, we've gotten an injunction, basically saying you can't play this song. And then someone else comes and creates a new field beat, and then all this creativity that you had come up with because we are here fighting, it's a past. So 5 years down the line, we conclude the case, but now that song, it's so back in the day. So now lawyering has evolved, and we have also what is called now protective lawyering, which for creatives, it's a term we have coined for them to understand. Protective lawyering means you are aware you have created something, you're able to sit down with a lawyer, they help you to protect. Because there it's not a cumbersome process, it's a peaceful process. It's something that you plan before you launch a project as well. So you don't just wake up in the morning and call a lawyer and say, I want 50 contracts. It's
right.
most important.
Okay, give me a rough idea. How much, I'm not asking for your terms and conditions, but roughly how much are we talking about? Because you see, if you tell me going to Kikoba, I remember before, was it 1,000 bob to get the form? You see, now I need, so that I say, oh, just 1,000 to get a whole collection, Now you ask yourself, then why was I not doing it? So roughly, if for example, I come to you and I say, I have this concept and I'm willing to work with one person and we want to do draft me a target of a contractor, how much does that cost me?
So it usually depends. So it's about negotiation.
It's about negotiation. In fact, that's what I'm saying, roughly. Because I know it depends from
person to person. To depend on the kind of idea or concept or whatever it is you have in place. So you find that most lawyers will have an initial consultation fee. Again, you negotiate for yourself because that's not subject to the remuneration order.
It's in free space.
Yeah, it's a free space.
It's you, the artist, and the lawyer. Okay.
So there we can have a conversation, and then you have that initial meeting. From the initial meeting, you get a roadmap from all this information you share. They say, okay, copyright. Okay, who are you working with? You need this kind of contracts. If you have mini contracts, of course, there will be some concessions.
Exactly.
We are negotiating.
Exactly.
So because now you're bringing bulk business, we're having that conversation. Sometimes some lawyers are also open to other ideas. We've seen lawyers also taking equity in startup firms and things like that.
Right.
It's about negotiating.
Okay.
But that initial consultation is always important because it will also help you to decide whether this is how you want to proceed, or you might want to change a few things. Because sometimes as artists, you have these fabulous ideas, but then you find you have no space in the law, or some of these things you want to do maybe even illegal or impossible, right? Or just very hard to navigate because policy, because legislation, So that initial consultation is always important. You have that first. So that then when you're doing your project, you do it in a systematic fashion. It's not just something you woke up and stumbled upon. So when you do that, you're able to find money and figure out how to protect yourself. Because we also have to, imagine a business being a person.
That's right.
You have to buy clothes,
Exactly.
You have to buy shoes.
True.
You have to buy innerwear. So think of it like that,
True.
right? So
True.
that initial consultation is like getting the underwear. Protecting. By the time you're looking fabulous, you're marketing, you're set. Yeah.
Got you. One question here. Do DJs have copyrights?
Okay, if you do not own it, it is not yours.
But I think I understand where this
Then
DJ is coming in from. Yes.
Then DJs will become now
Master mixers. Is that what we call?
No. They're those also but now become like composers in their own right, like DJ Khaled. He's now like composing music.
Correct.
In that respect, yes.
Mm-hmm.
But now in this mixing and whatnot, again, becomes an issue of derivative works, right?
That's right.
So because you're already using work that belongs to someone else, you have to either take out a license directly, or if you're performing in events, you will ride on the public performance license that the venue would have from the collective management organization, CAM, Kenya Association of Musical Producers, PRIS, Performers Rights Society of Kenya, MCSK, Music Producers Society of Kenya, Music Operators Society of Kenya.
Yes.
So yeah.
Okay.
So DJs don't have copyright really unless they create.
And if there are, what we call the normal in quotes DJ, they don't have copyrights.
Yes.
But they can create derivative works, and that means there are permissions to be sought. There are so many other things before they can get on.
And it's not easy because you just look at like the kind of music they will use. If it's international music, it means you have to have conversations with Universal, EMI, all these big record labels and publishers, right? So then you're figuring that out. If it's at the local level, you have to talk to the artists directly and find a working program or process.
Right.
It's no longer that because we realize that people are stuck in that mentality that DJs market us or market artists. So then for them they're like, I'm marketing you, so why am I paying you?
Well, if you agree, that's a personal choice.
Exactly. So there are labels that do that.
Yes.
So that's how even DJ became a thing. It's the labels who said, we need a disc jockey in a club. Right. We pay them some money so that we make sure every week when we have new songs, it's being played in the club and our artists are getting popular. That's how DJs came about. But now it's evolved, right? And now DJs are also now making money independently. So why would a DJ make money and leave the artist struggling, right? So even now as we are online during this COVID season, we saw DJs putting disclaimers, it's not mine, subject to US copyright. I'm like, are you in US or in Kenya?
So what they were doing during the COVID moment, really, in terms of getting mixes, they were playing for us, is actually copyright infringement.
Exactly. And some of them were taken down. Those that have not been taken down, it's not to mean it's correct or right. Yes. It just means that some of those songs that stayed online, the authors and their publishers and record labels were deliberate and said, they told Facebook or YouTube on the back end, any money or any benefits, channel them to our account. Okay. Yeah. So you won't get money because we did say that policing of infringement is up to the person who feels aggrieved. So they said, okay, we are going to reach an agreement with this DJ. We're going to say any advertising money you get is ours, but keep the work up. Yes. All right. And then the others who said there's a takedown notice. Take down. And you see, they're right. And a copyright. I can decide to make it available or not. So if I don't like what you're doing, we need out. Yeah. Last question, I think, because we are close to running out of time. If, for example, I have a competition and I submit my work, and these are creative works, what the person who has received them, or if I see my work, it does not win anything, but I later on see my work somewhere else, what should I look out for so that that does not happen? Terms and conditions apply. That famous phrase on this competition, I remember even as a kid, I used to hear terms and conditions apply. I'm like, where are these terms and conditions? But back then, I'm like, not my monkey, not my circus. True. That's what a few years down the line, I'm an IP lawyer. Indeed. And I'm like, terms and conditions. Right. Now I started looking, and then you see in some of the competitions, that's complete over there, you're like, You almost need a magnifying glass.
Right.
Like,
or even the question,
saying?
did you sign a contract, or did you look at any terms and conditions, or you just submitted?
Exactly. And you see, back in the day,
Yes.
those terms and conditions were at the bottom of that advertisement.
Oh yes, the advert of sending it the call. Yes.
Yeah, that's called. So back then, those were like, now those terms and conditions are
Right,
applied.
right.
I don't know if people used to read them back then. I was too young.
Yes.
So, but now fast forward with the digital space and TVs and all that, they will always tell you, go to the website or go to our social media or whatever it is. So you have to find these terms and conditions. When they say terms and conditions apply, it's a contract.
Right.
So find it before you enter your works. And then you read, what are their provisions? What are they saying? What happens when you win? What happens to your work if you do not win? Some of them would say, they would expressly state that should you submit, you automatically give up your copyright and we own it.
Yes.
Are you comfortable with that?
Yes.
Because at the end of the day, it's a contract.
Yes.
No one is holding a gun to your head.
You say yes.
Umekubali?
You say no.
Yeah, umekubali sawa. Tomorrow you see it on a coffee mug, on a bus, you say yes.
Right.
Tembea.
Oh my.
You made that conscious decision. Nobody forced you.
Indeed.
Right? So those terms and conditions become very important. You need to read the fine print to know what exactly will happen to your work. And if it makes you sleep at night, then fine.
Oh, I thank you, Liz. I thank you very much. And I hope that as we've been discussing, because the creative space is a space for artists who are business people. It's not, before it was idlers and people who have nothing better to do. These are people who are creating an industry.
Exactly.
So they're very serious about their work. They're very, passionate about their work, and it is a business. So I'm saying that strictly because sometimes when we are given contracts to read, we're like, where do I sign? And you start signing before even reading the contract. So just those few minutes that you would spend reading a contract protects your business. You're now taking you're CEO of your business, literally.
Exactly.
So it's the high time we embrace it and start acting as such.
Exactly. Yeah.
Thank you, Liz. It's been great having a chat with you.
Yes.
I think I'd like to hand over to Professor Kimani. I hope we have not overshot our time lot.
No, you have not. You've been absolutely phenomenal. We are really, really grateful to you, Kathy Mujomba, coordinator of copyright at the Go Down Arts Center, and Liz Lenjo, IP and entertainment lawyer. Really, thank you so much. You've teased out most of the issues. We are grateful. I'm sure that Wasanii Tunajisort is helping, the creative sector, and you've really set the bar pretty high for the other, sessions. So we are really, really grateful. And I have received lots of, text messages. How do I get in touch with them individually and so on? So we'll be reaching out to some of the people who are asking for your numbers and so on, through a different platform. So again, thank you so much, Kathy and Liz. Participants, I really want to thank all of you for today. As we said earlier, Wasanii Tunajisort is organized by a range of partners: the Creative Economy Working Group, UNESCO, Alliance Française, the Go Down Arts Center, and Taweza Communications. And this is part of a series of conversations driven by the practitioners in the arts sector. They're the ones who are determining the topics as well as the direction that will be taken in the conversations. I know that the next session will be on taxation in the creative sector, and we will be doing this in the next 3 weeks or so, because taxation is such an important area of work for the creative sector. How do we pay our taxes? Should we pay taxes at all? How much should we actually be paying? And so forth and so on. To whom should we actually be paying? So that will be the next point of conversation. And then we will also be asking the participants to guide us on the consequent topics that we shall have after October. And again, we'll be looking out to hear what practitioners would like to learn. Again, this is part of our professional development. It's part of really improving ourselves, getting to learn about our sector. And as I think Liz and Kathy have said, do read your contracts. And before you go to the lawyer, know what you really want first, so that you have a starting point. You really should get an idea of what it is you really want. And of course, some works, as they have told us, are work for pay, and you get paid and you're happy and you move with that. On your screen, you have a set of questions. I think I may have jumped the gun. You have a set of questions of possible topics for the future. Please do take 2 minutes to choose the topic that you would like covered in future Wasanii Tunajisort sessions. I think we can do like 1 minute. The first one is taxation in the creative sector. The second one is digital distribution of creative content. The third one is monetization of films online. The fourth one is maximizing LinkedIn profile. And the fifth is script writing techniques for short films. If you can take a minute to just select the topics that you think we should be able to cover in the consequent sessions, we'd really appreciate. So 1 minute, we just do it. And after you have selected, you submit. Yes, we have already started getting the analysis. I think the panelists also voted. The top oops, I think someone just pulled it off my screen before I could read the analysis, but clearly digital platforms coming out very, very popular, and taxation sequencing. So digital distribution of creative content, taxation scores at 81%, taxation in creative sector at 75%, monetization at 56%, maximizing LinkedIn at 44%, and script writing techniques for short films at 38%. The conveners will make a decision on whether to go with taxation first or to go with digitization first. But clearly, those two are critically important, and we'll be able to communicate with you in the next few days. So see you in 3 weeks' time. Again, thank you so much, Liz Lenjo. Thank you very much, Kathy. And thanks a lot to the partners, Wasanii Tunajisort. We are not waiting for people to sort us out. We are sorting ourselves.